Bienvenidos y bienvenidas a este nuevo webinar, a esta actividad organizada por el módulo Jean Monnet. Como ustedes saben, hay distintas actividades que estamos organizando en el marco de este módulo Jean Monnet que pertenece a la Universidad ORT. En este caso vamos a tener hoy un webinar que se titula La Unión Europea y el cambio climático, que busca ser una instancia de análisis y reflexión sobre el papel de la Unión Europea como un actor global en la lucha contra el cambio climático. Eh, Vamos a intentar explorar los aspectos más relevantes del Pacto Verde Europeo, abordando tanto sus fundamentos jurídicos como sus implicancias en la reconfiguración del comercio internacional, en un momento en el que las políticas ambientales y comerciales tienden a entrelazarse de manera creciente. Este webinar se va a estructurar en dos sesiones temáticas. La primera se titula El marco jurídico del cambio climático en la Unión Europea y va a analizar la arquitectura normativa que sustenta la acción climática de la Unión Europea y otros instrumentos claves. Eso va a ser ahora en la primera sesión de 10 a 12. Y la segunda sesión, titulada La Agenda de Comercio y Cambio Climático, divergen o convergen en el nuevo orden eh, comercial internacional, se va a enfocar en la interacción entre las políticas comerciales y ambientales, considerando los desafíos y oportunidades que plantea esta convergencia para los actores internacionales, en particular desde la perspectiva europea. Esa segunda sesión va a ser a partir de las 2 de la tarde, entre las 2 y las 4 de la tarde, y va a moderar Juan Labraga. Entonces, la sesión de hoy, de la mañana, el marco jurídico del cambio climático en la Unión Europea, lo va a moderar el doctor Juan Manuel Rivero Godoy. Juan Manuel es doctor en Derecho y Ciencias Sociales de UDELAR, es catedrático de Derecho Internacional de nuestra universidad, la Universidad ORT Uruguay, es presidente del ATCAM, el Centro Latinoamericano de Arbitraje y Mediación, es ex secretario del Tribunal Permanente de Revisión del Mercosur en el periodo 2020-2023 y además integra varias listas de árbitros, entre ellas la Cámara de Lima, RAC Rusia, Asociación Zambrano, Perú, CAMP Paraguay, AIADER de Malasia, KFCRI de India. Además es árbitro de la Cámara de Arbitraje Internacional de París. Juan Manuel, eh, the floor is yours, como dicen.
Bueno, muchas gracias, gracias por la presentación, Diego, y bueno, por lo que veo, a varias caras conocidas ahí en el chat, exalumnos, así que bueno, un gusto nuevamente estar aquí con ustedes. Bueno, la idea un poco de hoy es tratar de hablar un poco de lo que es el cambio climático dentro de lo que es un tema un poco más amplio que es el medio ambiente, ¿sí? Como ustedes sabrán, se habla mucho hoy de la cuestión medioambiental y hay una cierta equiparación cuando se habla de cuestiones ambientales a las que son básicamente la cuestión del cambio climático. Aunque hay ciertas cuestiones que tienen que ver un poco más con, diría, el lenguaje que se utiliza. Generalmente, toda cuestión vinculado al cambio climático es una cuestión medioambiental, pero no necesariamente todas las cuestiones medioambientales son cambio climático, ¿sí? Son aspectos bastante distintos, porque dentro de la cuestión medioambiental el cambio climático, como se le llama hoy en día, es una de sus aristas, pero no constituye su totalidad. Porque cuando hablamos, por ejemplo, de el derrame de un barco que transporta combustible, difícilmente ahí hablamos de cambio climático, lo que hablamos ahí es de contaminación ambiental, que no necesariamente tiene el impacto que puede tener otro tipo de actividades para lo que es el calentamiento global. Entonces es importante a veces también tener en cuenta que esa pequeña diferencia, ¿verdad? Que cuestiones ambientales son muchas más amplias o abarcativas que la cuestión del cambio climático, que es algo bastante más concreto y que recién tiene una carta de presentación para lo que es la comunidad internacional a partir de la década de los 90, recién con la Declaración de Río. Ahí comienza realmente, y cuando se adopta la Convención Marco de Naciones Unidas para el Cambio Climático, que tenemos el primer gran hito a nivel de lo que tiene que ver específicamente con la cuestión del cambio climático. Es decir, hasta ese momento lo que se hablaba era de las cuestiones ambientales y eventualmente de la problemática que podría implicar para el futuro, ¿verdad? La cuestión de el calentamiento global. Pero no es recién hasta la década del 90 que se le da una carta de presentación y comienza una agenda importante a nivel internacional, que luego, como les mencioné, de la Convención Marco de Naciones Unidas del año 92, se adopta el protocolo de Kioto en el año 97, 98, y luego tenemos como segundo o tercer granito es el Acuerdo de París. Es decir, uno podría afirmar que hoy la cuestión del cambio climático es algo que está instalado, ¿sí? Y está instalado verdaderamente en lo que es la psiquis de las personas, de la academia, pero que también tiene ciertos contrastes, ¿sí? Contrastes que aún muestran que llevar a tierra todas estas cuestiones normativas, todos estos acuerdos, o sea, todas las regulaciones que también, por ejemplo, tiene la Unión Europea, que en eso es muy exhaustivo, por lo menos al interior de la Unión Europea, eh, no son tan fáciles de llevarlas luego a la práctica, porque hay ciertos bemoles, es decir, hay ciertos contrastes. Sobre todo, capaz que si algunos de ustedes han seguido las COP, ¿verdad? Las conferencias de Estados partes, van a ver que hay muchas críticas sobre estas conferencias y los verdaderos avances que se han logrado, y tiene ciertas explicaciones desde el lado de la academia y desde el lado de la práctica. Es decir, una cosa son quienes toman las decisiones a la hora de regular lo que se considera importante alrededor del cambio climático, y otra cuestión es quienes tienen que de alguna manera aplicar esas normas, sobre todo cuando hablamos de comercio, que ese es un pequeño detalle no menor. Es decir, siempre lo he explicado en algunos foros, probablemente a un CEO de una compañía, de una multinacional que se dedica al tema de recursos energéticos, le parezca muy interesante todo lo del Green Deal en Europa, le parezca muy interesante lo de los bonos de carbono, el protocolo de Kioto, los estándares, etcétera, etcétera, las certificaciones y el tema de volverse, como siempre digo, un poco más verde. Pero hay una realidad que es que eso requiere también de inversión y desarrollo. No todas las compañías tienen la intención, por diversas razones, a veces de escala, por su nivel de producción, a veces porque no es parte de una política de la empresa, a veces también porque no hay incentivos para llevar a una compañía a volverse verde. Entonces eso hace que también la práctica, cuando uno analiza más en profundidad, vea ese contraste entre lo que es la política internacional y política interna alrededor del cambio climático como una cuestión de vida o muerte, que es como se lo presentan muchos foros, ¿verdad? Sobre todo de poder alcanzar de aquí a 20, 30 años una disminución de tantos grados. Y la realidad indica que hay una distancia bastante importante entre lo que es esa cuestión política normativa plasmada en documentos y en diferentes normas, y lo que está pasando en la realidad. Entonces, para eso tiene que haber una alternativa, ¿sí? A las grandes compañías de recursos naturales o de diferente tipo de actividades que pueden implicar el aumento, ¿verdad?, de la emisión de dióxido de carbono, puede que para pasarse a ser más verde o para que un CEO convenza a sus accionistas de que hay que hacer una inversión, eso requiere también de una alternativa, y una alternativa para la mentalidad en el comercio también implica ver cómo se traduce eso en términos de ganancia económica, ¿sí? Entonces, ahí es donde encontramos, yendo un poco a la práctica, algunos de los pequeños problemas, ¿sí? Porque probablemente para los accionistas de una empresa no les interese mucho si volverse más verde es una cuestión más de eslogan o de publicidad, sino si al final del año tienen el mismo nivel de rentabilidad o de utilidades. Les digo para que un poco entiendan también por qué a veces, pese a tener tantas normas, y como siempre digo, van a seguir habiendo más normas, porque el Acuerdo de París ha tratado de dar un paso más de lo que fue el protocolo de Kioto, y el protocolo de Kioto trató de dar un paso más de lo que fue la Convención Marco de Naciones Unidas del año 92. La realidad indica que muchos países tienen normativa muy avanzada, Uruguay también tiene normativa muy interesante en materia de medio ambiente y cuestiones vinculadas a las contribuciones nacionales para disminuir eh, la emisión de gases, ¿verdad? Que pueden generar el llamado en su momento efecto invernadero, que se le dice el cambio climático, pero la realidad indica que a nivel de derecho comparado aún se está muy lejos de eso. Esa es una realidad, por algo sigue siendo una preocupación. No voy a entrar en el detalle sobre los detractores del ámbito del cambio climático, porque ustedes también conocerán que hay detractores. La administración Trump es una de ellas. Por eso quizás hoy, si hoy le quisieran preguntar a James May, que va a ser el expositor sobre qué opina sobre, bueno, o las consecuencias que ha tenido la administración Trump en el tema del cambio climático, creo que pueden quizás hacerle alguna pregunta como para tratar de tener de primera mano un poco esa cuestión más en puerta. Ahora bien, como les mencionaba anteriormente, la cuestión del cambio climático no deja de ser una problemática instalada que tendrá, como dije, sus argumentos a favor y en contra, pero sí lo que es importante que vean, y les reitero, es que hay una cierta distancia entre lo que tenemos a nivel normativo y lo que se manifiestan en los foros de lo que es la práctica. Ahora bien, por otro lado, que es uno de los aspectos que también James May va a tocar, es el tema de la litigación en materia de cambio climático o temas medioambientales, porque eso es una cuestión no menor. Las normas, que se supone que han sido creadas con el objetivo de regular los diferentes tipos de acciones o los diferentes tipos de conductas que están alrededor y que pueden afectar la cuestión medioambiental, requieren también bajarse a tierra, es decir, cómo se reclama, cómo se plantea un reclamo a nivel de cambio climático, porque cuando hablamos, y lo hemos visto quizás en algunas clases, son cuestiones parecería muy abstractas, muy amplias, que involucran a varios actores, es decir, la cuestión climática no es una cuestión que involucre a dos personas, involucra a estados, involucra a organizaciones internacionales, involucra a empresas, involucra a personas, a grupos, a sociedad civil, es decir, la cuestión del cambio climático es algo transversal. Entonces, ¿cómo se hace para bajar un reclamo de cambio climático en el día a día? ¿Dónde se puede reclamar una cuestión de cambio climático? ¿Se reclama ante tribunales nacionales, domésticos? Primera pregunta. Si no hay buen eco en el ámbito interno, esto se puede llevar a un tribunal internacional. ¿A qué tribunal internacional se puede llevar? ¿O estamos hablando de cuestiones que son bastante impracticables por la complejidad que tiene? Y ahí es donde empezamos un poco a navegar en las cuestiones prácticas, ¿sí? Del tema medioambiental. Y esa es una problemática no menor, ¿sí? Vayamos a, por ejemplo, a nuestro país. Uruguay también tiene, como les dije, una normativa bastante moderna en materia de cuestiones de cambio climático. Además, Uruguay ha sido uno de los países que ha contribuido en tiempo y forma con las llamadas contribuciones nacionales del Acuerdo de París, pero obviamente que todas las sociedades en su mayor o menor medida también dependen un poco o aún dependen de esa matriz de lo que es el combustible fósil, que son una de las grandes actividades que genera la emisión, ¿verdad?, de los efectos de los gases de efecto invernadero que genera el calentamiento global. Uruguay no es la excepción, o sea, sucede en todo el mundo. Y si no lo ven con las noticias, fácilmente cuando hay algún conflicto y se habla siempre del aumento o no del petróleo y eso influye obviamente en el resto de precios a nivel interno y lo que puede generar eso a nivel de impacto en una economía. Entonces quiere decir que aún si uno va a la realidad, todavía estamos un poco o bastante lejos de lograr cumplir realmente los objetivos del cambio climático. Y durante la guerra a los inicios entre Ucrania y Rusia también quedó demostrado. La Unión Europea, inclusive Alemania, en su momento se habló sobre la posibilidad de eh, reabrir o volver a la cuestión del carbón. Y eso fue bastante llamativo porque se supone que la Unión Europea tiene, ¿verdad?, un plan A, un plan B y un plan C para la cuestión del cambio climático. Y bueno, un poco la guerra desestabilizó esos planes, o por lo menos no estaba claro si realmente esos planes estaban de alguna manera consolidados. Quizás muchos de ustedes no conocen esto, pero la Unión Europea no ha dejado de comprar petróleo a Rusia. Lo que pasa es que lo trianguliza a través de otro tipo de países aliados de la Unión Europea, pero que no tienen mala relación con Rusia. Entonces ahí uno entra un poco en esa especie de intriga de decir, bueno, realmente, a ver, la normativa que hoy la Unión Europea tiene es muy interesante, es muy desarrollada, tiene el llamado Pacto Verde, donde hay una gran contribución de millones y millones de dólares para, mejor dicho, de euros para tratar de que la Unión Europea se vuelva cada vez más verde, pero aún su gran matriz económica, productiva, depende del petróleo. Entonces ahí hay una especie de problema porque eso genera una cierta contradicción con todo lo que les venía manifestando recién. No solo la Unión Europea, es a nivel internacional, ¿sí? No pasa solo en la Unión Europea. Obviamente que hay países que tienen quizás mayor grado de avance, porque bueno, quizás la economía les permite por diversas razones poder tener una economía, llamémosle quizás más verde, pero no deja de ser una cuestión interesante, ¿verdad? Entender que hoy en día la cuestión del cambio climático es muy dispar a nivel de países. Para muchos países el cambio climático, quizás lamentablemente, no es algo prioritario, ¿sí? Difícilmente uno puede llevar la idea del cambio climático a determinadas zonas del planeta, donde los problemas son otros, ¿sí? Entonces es muy difícil lograr que en esos países donde además generalmente se instalan empresas que realizan actividades que van en contra de el cambio climático, uno pueda, por el tema de la desregulación, por el tema de la pobreza, por el tema del marco normativo endeble, ¿sí? Ustedes si analizan un poco, las grandes empresas también europeas que no pueden desarrollar mucha actividad que puede afectar el cambio climático, se trasladan hacia otras latitudes, donde buscan marcos más flexibles. Entonces, cuando uno empieza a hacer un análisis un poco más en profundidad, se empieza a dar cuenta que en realidad lo que pasa a nivel normativo político difiere bastante de la práctica, ¿sí? Y eso es por lo que les decía recién. Hay un patrón de producción o de consumo a nivel de la humanidad que hace que todavía dependamos de lo que mencionaba recién, de determinado tipo de técnicas a la hora de producir, a la hora de consumir y a la hora de utilizar determinado tipo de materias primas. Eso se supone que es uno de los grandes focos contra los cuales se trata de pelear. Pero si ustedes analizan la normativa a nivel internacional, lean la Convención Marco de Naciones Unidas, lean el Protocolo de Kioto, lean el Acuerdo de París, se van a dar cuenta que no se habla de erradicar. La palabra erradicar básicamente no existe. Lo que existe son palabras tales como adaptación o mitigación. ¿Qué quiere decir esto? Que se es consciente que no se puede erradicar de una vez y para siempre todas las actividades que hoy tenemos que generan, ¿verdad?, el calentamiento global, ¿sí? O sea, es imposible. Por eso los tratados hablan de medidas que mitiguen o que se adapten para de alguna manera contrarrestar algunos de los efectos del cambio climático. Pero es una realidad que en el mediano y largo plazo es muy difícil dar una vuelta de tuerca a todo esto que les decía recién. Eso también se refleja en las reuniones de las COP, donde realmente ahí es muy interesante, donde se reúnen los estados y quizás alguna parte de la sociedad civil, pero pocas veces está presente justo lo que yo considero que es importante, que es la parte que tienen los medios de producción a nivel internacional, las grandes compañías, los grandes consorcios, que son los que también tendrían que implementar estas medidas e invertir en tecnologías más verdes. Pero las tecnologías más verdes, mis estimados, tampoco son baratas, ¿sí? Requieren inversión, requieren desarrollo, requieren investigación. Entonces ahí vamos a entrar a ver que también esa dinámica es muy distinta de lo que nosotros quizás nos podemos imaginar. A nivel de eslogan es muy lindo, es muy interesante, pero yo creo que los objetivos también tienen que estar alineados con cierta cuota de realidad, ¿sí? Ustedes sabrán bien que los países por lo general no son productores de casi nada. O sea, lo que hacen los gobiernos de los estados es facilitar un marco jurídico donde se pueda accionar y actuar, pero quienes producen son los privados. Entonces, si los privados no adoptan al cambio climático como una urgencia, como una prioridad, va a ser muy difícil que veamos grandes cambios significativos en el mediano y largo plazo. Esto no es una visión, a ver, negativa ni funesta, es una visión realista, porque en todos los foros que ustedes van a ver, se habla más o menos de lo mismo que les hablé yo, con mayor grado de profundidad en algunos puntos y menores en otros, pero hay que entender también cómo funciona la lógica del comercio. La lógica del comercio es muy interesante, pero es una lógica que basa su potencial en la maximización de las utilidades al menor costo posible. Eso difícilmente cambie. Si no, vayan al ámbito de la OMC, que ha sido la institución internacional creada para justamente regular el comercio internacional, son muy pocas las normas que ha logrado consensuar a nivel de medio ambiente. Entonces, si ustedes un poco atan los cabos, y ven cuántos países han firmado, cuántos han ratificado los acuerdos medioambientales, cuántos realmente los han cumplido, y ven el ámbito de la OMC, se van a dar cuenta que no hay un gran consenso sobre la urgencia, por lo menos para algunos países. No quiere decir que no sea importante, pero no es la urgencia desde el punto de vista de qué, de la toma de medidas. Entonces, cuando uno baja todo esto a tierra, empieza a encontrar que todavía hay mucho trabajo por hacer, se requiere un cambio de mentalidad, pero se requiere acción. Y la acción es, bueno, si cambiar toda una matriz energética, por decir algunos de los elementos que tienen como variable conexión directa con el llamado cambio climático, y ustedes ahí analizarán qué tan viable es eso, qué tan viable es que Uruguay cambie de aquí a 20 años toda su flota de transporte o sus vehículos, pasarlos a no depender ya del combustible, sino de la energía eléctrica. ¿Alguno tiene una respuesta? ¿Alguno puede afirmar que eso puede pasar de aquí a 10, 15, 20 o 50 años? O sea, si alguno puede, me parece bárbaro y felicito esa cuestión, pero realmente, ¿cuáles son las posibilidades? Ejemplo, ustedes saben que desde los que estudian la cuestión del cambio climático, la actividad ganadera es una de las actividades que más genera esta problemática, según los estudios que se han hecho. ¿Cuántos dejarían hoy de consumir grandes cantidades de carne? Cuando, por ejemplo, para Uruguay la exportación, o para Paraguay, o para Argentina, o para Brasil la exportación de carne es un elemento sustancial. ¿Dejarían de comer carne para favorecer la disminución de 1,5 o 2 grados de aquí a 20 años? Entonces, ¿cómo afecta una medida de ese estilo a la economía de un país? Entonces, como ustedes ven, las normas son muy lindas, son muy interesantes, los acuerdos también lo son, pero a la hora de bajar esto a la práctica, uno empieza a encontrar que hay ciertas cuestiones que no hacen que el cambio climático sea algo tan, como dije, urgente para algunos países, sino que no deja de ser importante porque es una cuestión a tener en cuenta, ¿sí? Porque quizás el día de mañana muchos acuerdos se exijan para el intercambio de bienes certificaciones, que hay que cumplirlas, pero que eso va a depender un poco del desarrollo de cada país también. Si yo no le puedo exigir a países de África, por ejemplo, donde el mayor problema es el acceso al agua potable, que piensen en todo esto que estamos hablando nosotros en materia de cambio climático, porque quizás no es una prioridad. No quiere decir que no sea importante, pero no es una prioridad. O determinados países donde quizás los regímenes democráticos y su estabilidad son más importantes que una medida de cambio climático, ¿sí? Entonces ahí es donde empezamos a encontrar esa diversidad de situaciones. Otra cuestión de interés, yendo a los tribunales internacionales. Eh, Son muy pocos los casos que han llegado, por no decir escasos, salvo algunas opiniones consultivas sobre la cuestión del cambio climático y cómo puede afectar, por ejemplo, a el aumento del nivel del mar, o cómo se trata la cuestión climática y su importancia en cuanto a obligaciones que tienen los estados, como se ha tramitado, por ejemplo, ante la Corte Interamericana de Derechos Humanos. Pero la realidad es que las opiniones consultivas son eso, son opiniones, ¿sí? Que no obligan a los estados, ¿sí? Simplemente les dice qué es lo que eventualmente un tribunal internacional piensa sobre ese tópico, si llegara un caso de verdad. Pero para que ustedes tengan una idea, hasta los primeros años del 2000, para la Corte Internacional de Justicia, todavía no se podía hablar que las normas medioambientales fueran normas aceptadas a nivel internacional por la gran cantidad de estados que hoy tenemos, ¿sí? O sea, la propia Corte no pudo afirmar que realmente se había convertido, que ustedes ya lo han visto cuando vimos algunas clases sobre el concepto de ius cogens de las normas ambientales. O sea, la Corte dijo que no podía afirmar que las normas ambientales habían adquirido un estatus tan importante porque no se reflejaba en la práctica de los países. Entonces, como siempre digo, la normativa es muy buena, es muy interesante, es muy enriquecedora porque obviamente marca una agenda, pero todavía el gap que hay entre esa agenda y la práctica dista mucho. Y eso porque, como siempre digo, y pese a que a mucha gente no le guste, hay una realidad. Alguien tiene que pagar por esto, por la energía limpia. Alguien tiene que pagar por la investigación. Tiene que haber alguien que financie. Y como les dije, hay muchos países que sí tienen la posibilidad, pero hay otros que no. Y mientras eso implica un costo, sobre todo a nivel de empresas, a nivel internacional, vamos a seguir encontrando todavía estos desfasajes, ¿sí? Entonces creo que ahí un poco la cuestión del medio ambiente se vuelve bastante más, eh, no voy a decir endeble, pero sí ustedes van a tener que ahí encontramos algunos contrastes y no quiero que se vayan con la idea de que no es importante la cuestión del cambio climático, sí lo es, pero también está bueno que vean un poco eh, un reflejo de lo que es la realidad. Y lo pueden ver ustedes, no es necesario que yo se los cuente. Ustedes son estudiantes de una carrera internacional. Supongo que cada tanto deben estar analizando, leyendo y viendo las noticias, pero lo van a ver que las cuestiones aún de medio ambiente siguen siendo una problemática para casi todos los países, ¿sí? Cada tanto tenemos un derrame de petróleo, cada tanto tenemos la fuga de algún reactor nuclear, cada tanto tenemos los problemas con el transporte internacional que sigue generando contaminación o determinado tipo de producciones, o la cantidad de vehículos que se siguen produciendo todavía, que van y dependen del combustible. ¿Sí? Entonces, si uno analiza elementos prácticos, se va a dar cuenta que todo eso, llamémosle entre paréntesis, conspira contra lo que es cumplir con algunas de las normas que establecen los acuerdos internacionales, ¿verdad?, para con los países. Ni hablemos también de la problemática que implican esos acuerdos internacionales en materia de obligaciones. Ustedes saben también que hay muchos países que firman los tratados, no los ratifican, por lo tanto difícilmente tomen la acción de aplicar los tratados, porque como no los han ratificado, todavía el tratado no les impone demasiadas obligaciones, salvo la de no frustrar el objeto y fin del tratado. Pero después hay muchos países que realmente a los tratados internacionales en materia de cooperación no los consideran tan obligatorios como otros tipos de tratados. Eso lleva a que, lamentablemente, tengamos también que ver que a veces los países ponderan más una buena inversión, ¿verdad?, que tener o cumplir con los estándares realmente, como dice el tratado, de si tal actividad va a contaminar o va a tener una afectación o impacto directo con el cambio climático. Entonces eso, de alguna manera, nos muestra, ¿verdad?, que seguimos con esa situación de diferencias sustanciales entre lo que es la teoría y la realidad, que no es algo ajeno a lo que es el derecho internacional en general. No es una problemática única del cambio climático, hay otros tantos más. Simplemente este es un ejemplo porque hoy el tema del cambio climático se ha vuelto algo muy no sé si de moda, pero parecería que todo es cambio climático, y yo por eso hice la aclaración al principio. Hay cuestiones que pueden tener vinculación con el cambio climático, pero creo que no tienen un encuadre correcto, ¿sí? Sino que tienen que ver más con cuestiones medioambientales de otra naturaleza, ¿sí? Y no tiene que ver específicamente con lo que es cambio climático. Bien, hasta acá alguna duda, alguna pregunta que quieras hacer o algún aporte para hacerlo un poco más entretenido. Si quieren dar algún comentario mientras espero que se conecte James, que se tendría que estar conectando ya en breve. Si no, sigo hablando. ¿Quieren alguna? Ah, tenemos a James. James, how are you?
I'm doing well. I'm doing well. Is the audio okay?
Yes, thank you, James. I'm going to introduce you to our audience, okay? And then, well, you are going to speak. Bueno, voy a presentarles a James. Yo tuve la oportunidad de conocer a James en 2016. James es un experto en temas de medio ambiente y cambio climático. Yo lo conocí en 2016 cuando estuvimos en Johannesburgo, en Sudáfrica, en Potchefstroom, donde trabajamos con el relator de Naciones Unidas para el cambio, para el medio ambiente y los derechos humanos. James es un experto en estos temas, es un practitioner, ha litigado en estos temas, por lo tanto van a tener de primera mano un poco lo que les decía al principio, que es toda la cuestión vinculada a cómo bajar un poco a tierra los reclamos en materia de medio ambiente y cambio climático. James, sorry, I was speaking in Spanish just to say some words about when I met you first time in South Africa in Potchefstroom. And then I went to visit Delaware School in 2018, I think. My memory is not so good nowadays, but well, I'm going to introduce James May. James May is Richard S. Wright Distinguished Professor of Law at Washburn University and founder of the Global Environmental Rights Institute and Dignity Law Institute at Washburn University Delaware Law School, where he serves as Distinguished Professor of Law Emeritus. He teaches constitutional law, environmental law, and human rights. May is a human rights litigator who has worked on the constitutional law dimensions of numerous environmental and climate cases in domestic and international tribunals. May has published 20 books, including Global Environmental Constitutionalism in Cambridge, Principles of Constitutional Environmental Law Institute, and more than 100 articles, most recently including Subnational Criminal Rights, University of Pennsylvania, and Dignity Rights in America, Vienna Journal of Comparative Constitutional Law. May, it's a real pleasure to have you. Thanks for your time, because May is now in Poland. And well, I talked to students that, well, you are going to talk about your experience. You are going to contribute for sure with all your background and try to connect this theory and practice, because you have experience as litigant. So, as I mentioned, it's a real pleasure to have you. And well, James, the audience is all yours. Thank you.
Okay, well, thank you, my friend. It's a real pleasure to be with everybody, to be with you. Buenos dias. And thank you, Dr. Rivero Godoy, for inviting me. This will be all in English. I hope that's okay. I'll try to speak slowly. So I'm going to be talking about international environmental law in action, where it comes from, how it's applied, where it makes a difference, maybe where it hasn't as much. And I hope there's time for questions. So, Dr. Godoy, when should I wrap up my remarks? By what time do you think?
We have 1 hour and a half, so you are free to speak. No problem. If you finish before, no problem as well.
Okay, so I'll try to limit it to, what is it, 10:35. I'll finish by 11:15, okay, with my remarks, certainly. And
Excellent.
again, I hope, I hope for questions because that's the fun part for me. So, international environmental law is complex. It's not even easy to teach. It involves so many different facets. And it's sort of like water too. You can't really hold it in your hand. It just slips through in a whole variety of ways. But it starts off with treaties, as you've heard about, and then it has rights-based components, and then it has other components. Uh, some environmental law comes from treaties. Treaties are bilateral and multilateral agreements at the international level to try to address, various things, everything from the Geneva Convention to the Paris Accord. And most treaties are negotiated through UN mechanisms, that is like the United Nations headquarters in New York City. So the Sustainable Development Goals are a treaty because any kind of international agreement is a treaty, whether it's called a protocol or an accord or anything else. So that's where most of environmental treaties come from. The Basel Convention, the Montreal Protocol on ozone depleting gases, and so on, by and large negotiated through the UN and through the United Nations Environment Program in Nairobi, Kenya. But that's not all. Some of international environmental law is rights-based. Like this conversation about whether there's an international right to a healthy environment, um, and rights of children, and rights of indigenous populations, and so on. Those treaties are negotiated for the most part through the United Nations in Geneva, and they have various applications. And then there are mandate holders that implement those treaties, special rapporteurs, for example, like on the right to a healthy environment or against toxics, or for climate change. So those are folks who start off with some kind of a mechanism through the United Nations Human Rights Council. And then there are regional agreements that are still international law. Um, there are, it starts off with, I mean, they're all really adjuncts to the Universal Declaration of Human Rights. But you know them well, right? The American Convention on Human Rights, the American Declaration on the Rights and Duties of Man, the European Convention on Human Rights. Those are regional mechanisms for advancing human rights. Now, in the middle between those regional mechanisms and international law, so Juan, I can't understand that if that's meant for me anyway. If there's a message. Okay, sorry. All right. So between international law at the UN level and regional agreements, you have the Bill of Rights that are reflected in two covenants. They're both international, the International Covenant on Economic, Social, and Cultural Rights, and the International Covenant on Civil and Political Rights. So that is sort of the scaffolding, uh, the outline of where international environmental law can come from. We don't have an international environmental law treaty, just a general environmental law treaty. But there are various kinds of treaties that reach the environment, of course, as you know about. Some of them are subject-based, again, like for ozone depleting gases, that's the Montreal Protocol, or climate change, um, that's the Paris Accord. Some of them are process-based, like the Escazú Agreement and the Aarhus Agreement on information, participation, and access to justice. So that's kind of a framework of where international environmental law comes from. But that's not all, because there are these feedback mechanisms from domestic courts, both going and coming. On the going part, uh, sometimes domestic developments can inform and push international developments. The domestic development of constitutional recognition of an environmental right, for example, has pushed efforts to internationalize recognition of environmental human rights. Also coming the other direction, under some constitutional systems, some constitutional courts and apex courts have to consider international developments, like the Constitutional Court of Colombia and the Constitutional Court of South Africa. I'm not sure, Dr. Godoy, does the Constitutional Court, or how does it work in Uruguay? Are courts permitted to consider international law, or are they required to consider it?
Well, it's a interesting question. Sometimes there are some frictions because we don't have a specific constitutional rule in which part of international law how it fits, if all over the law or behind the law or under the law. So it's a little bit complicated. It is supposed that the Supreme Court has to try to unify international law according to the national law. It's an engineering job, to fit. But well,
Okay. Okay. But it sounds like, there's a role for international law in some way, shape, or form, like you say, either over, under, or through. So that's very different than in the United States. In the United States, uh, certainly federal judges, they're sort of prohibited from considering international law developments, which is so weird, but that's our tradition. So that's kind of a framework for international environmental law. You may wonder, well, what about uh, cases? What are the main cases? What's happened? What's going on to enforce these provisions? So international treaties are only as good as the extent to which countries abide by them, recognize them. And so there are, developments in that regard. Uh, Today, in June of 2025, some of the leading cases aren't even cases. They're advisory opinions. Next week, it's expected that, for example, the Inter-American Court of Human Rights will issue an advisory opinion on the obligations owed to future generations affected by climate change. So that's international law, even though it's an advisory opinion, and it's kind of like a case, but it's an opinion and not a contentious case, but it's super important. There's also an advisory opinion that will be issued in the coming months from the International Court of Justice at The Hague, which in essence involves the same question. That is, what's the obligation that countries that are responsible for climate change owe to future generations? So those are some recent cases that aren't even cases. Now, that said, there are lots of cases out there that push the environmental law envelope. Many of them are at the regional level. There are thousands of petitions that are pending, for example, before the Inter-American Commission on Human Rights, that concern environmental contamination, toxic chemicals, water pollution, and so on. So we see really environmental law living at the regional level before international regional bodies. There are also hundreds of cases that are pending before the European Court of Human Rights, and not as many, but also nearly as many cases pending before the Inter-American Court of Human Rights. So there aren't as many cases pending before other regional bodies, but what we see there is international mechanisms for enforcing environmental law at the regional level. But that's not all. We also see environmental law even having international dimensions to it, litigated in domestic courts, before national courts, that is. Uh, so some of the leading cases in that regard go back decades. Some of them, for example, come out of the Supreme Court of India, upholding that Article 21 of the Indian Constitution, which affords a right to life, that right to life includes a right to a healthy environment. So those are some early cases that where we see environmental protection through rights-based mechanisms at the state level. And more recently, there has been an awful lot of and more cases about climate change. Again, as you heard about in the good doctor's remarks before I joined. And some of those cases are from the United States, like the Juliana case versus United States, where the plaintiffs argued that there was a fundamental right to a climate capable of sustaining human life. And that case was just dismissed a couple of months ago after being litigated for 10 years and never got to the merits of it. There are other cases where national courts have engaged the question as to whether there's a violation of a right to a healthy environment. Sometimes those cases are winners, if you will, like in the Urgenda case, where a Dutch court found that the Netherlands climate policies violated its obligations under the European Court of Human Rights. I'm sorry, the European Convention on Human Rights. But more often, cases are losers, like the case out of Norway, um, which has an environmental rights provision that the litigants there were trying to enforce, and the court found that that provision wasn't violated. And then there are other cases that that are litigated all around the globe. Tutela cases, of course, in South America, public interest litigation cases in Nepal and Bangladesh and Pakistan and India, um, and cases throughout the Pan-Asian system as well, including in China and Australia and New Zealand, and cases in North America in addition to the United States, including in Canada. So there are environmental cases that are being brought all around the globe. And what they have to do with international environmental law is many of them are enforcing the law that their country requires to be followed according to a treaty. And many of them, even if not, are applying international principles in those cases. Next is some developments. Um, there are a lot. I mean, every day there are developments in international environmental law in Europe, in North America, and South America, and Central America, and Africa. All around the globe. It's hard to keep up. So let me just focus on a few. A few developments. One is a plastics treaty. So recently, and we're getting back to different kinds of treaties. Uh, there's a multilateral agreement really to agree about plastics pollution, which is a major problem clogging oceans, the Pacific Ocean in particular. Um, and so there's an effort to do something about that. Um, there is talk of an international treaty to protect human rights defenders. There has been some progress on that as well, and especially for environmental human rights defenders. Uh, there is a talk at the international level about UNCLOS, the United Nations Law of the Sea Convention, and how to make that apply to climate change. Um, uh, but there are developments in the other direction, some that have just happened over the last 24 hours. You know, uh, Countries in the European Union yesterday agreed to increase defense spending to up to 5% of gross GDP, gross national product. And where that money is going to come from, it isn't from increasing taxes for the most part. It's not from increasing revenue. It's by cutting funding for renewables and for climate mitigation. So even though that isn't international environmental law per se, it's a development that will have every bit as effect on climate change as would a climate-based treaty in the European Union. Other developments that I want to focus on are two. One is about recognition of a right to a healthy environment, and the other is about the right to human dignity, which is having huge impacts and environmental outcomes throughout the globe, and sometimes in unexpected ways. So on the right to a healthy environment, again, you probably know all this, you've heard about this, so forgive me if I'm repeating too much from what you've already been taught. But we don't have an international treaty recognizing a right to a healthy environment. Uh, we don't have a treaty recognizing, I'm sorry, providing a cause of action and having it be enforceable and having a compliance mechanism. We don't have that. But what we do have uh, are two things. First is a United Nations General Assembly um, uh, resolution from 2022, a few years ago, recognizing the right to a healthy environment. And just in the year before that, in 2021, the UN Human Rights Council also recognized a right to a healthy environment. So you may wonder, where does all that come from? Well, it started with the Stockholm Declaration in 1972. A long, long time ago, countries from around the globe got together and drafted a treaty, a declaration about environmental values. And the very first clause of that treaty recognizes everyone's right to a healthy environment. Uh, it sort of sat there for a couple of decades, though, um, before there was further progress. You see, there wasn't an international treaty following that to make it enforceable, but countries started to amend their constitutions to incorporate a right to a healthy environment. Yugoslavia actually got there first in 1974, uh, and then there is no Yugoslavia any longer. So the longest running country to have this kind of provision is Portugal, which amended its constitution to incorporate a right to a healthy environment in 1976. So Portugal was the first country to recognize that right. And really its inspiration was the Stockholm Declaration. And in some ways, the inspiration for the Stockholm Declaration came from the Universal Declaration of Human Rights. And before that, the American Declaration on Human Rights, and just this recognition of rights-based approaches in international law. So, since Portugal adopted a right to a healthy environment or recognized that right, again, as you probably know, being in Uruguay, that there are 85 countries by my count, 85 countries that have an express right to a healthy environment. Uh, there are 194 UN recognized countries at this point. So you may wonder, what about the other countries? Well, of the remaining countries, about six or seven recognize a right to a healthy environment as incorporated in some other socioeconomic right, like a right to life or health or dignity. Leading examples of that are India and Bangladesh and Nepal and Pakistan. So, all told, all around the globe, somewhere around 90 countries recognize a constitutional right to a healthy environment. But another 50 or so have recognized a right to a healthy environment by signing on to some other treaties, like the Aarhus Convention or the Escazú Agreement, for example, both of which recognize everyone's right to a clean, safe, healthy, and sustainable environment. So that's sort of the development of recognizing a right to a healthy environment in law, in international law, and how it's incorporated at the domestic level. The other development that I mentioned is about the human right to dignity. Now, the right to dignity is just about the oldest recognized right in international law. It's in the very first sentence of the American Declaration on Human Rights, which was adopted 6 months before the Universal Declaration in 1948, and it recognizes the inherent right to human dignity. That's recognizing and understanding the equal worth of every human being. Um, so where has that gone? Well, the right to dignity is incorporated in lots of constitutions around the globe. By my count, there's an express right to human dignity in about 50 countries. So about 50 countries throughout the globe recognize a right to human dignity. And what we see is in many of those countries, courts, judges have turned to the right to dignity uh, when confronted with cases involving environmental degradation, dirty water, unsanitary conditions, toxic chemicals, even climate change. uh, courts have turned to that right to dignity in addressing environmental harms. Um, so there are additional developments just to point out. Uh, One is really backsliding. Again, this is just from what's happened recently. There has been international movement for 5 years or so for the development of some kind of international standards regarding corporate practices and business practices. And this is largely reflected in efforts to adopt environmental, social, and governance standards called ESG. Um, in the United States, we don't have an ESG law, but for a while it looked like we would, especially during the time when Joseph Biden was president. The Biden administration pushed for standards for business practices, kind of an implementation of the Ruggie principles about human rights and business practices. And also, there were similar efforts to establish ESG rules in the European Union. But anyway, these haven't come to pass, really. I mean, the European Union, they have a bit, but they've been watered down. But in the United States, we don't have any rules requiring standards for economic, social, and governance concerning corporate practice. And that's largely because when we changed administration 6 months ago and Donald Trump became president, a priority for President Trump has been to rescind and reverse uh, just about every environmental law, rule, or regulation that he can. And among the early ones that he went after was this rule about ESG. He also did the Trump administration uh, uh, disbanded, dissolved programs concerning environmental justice. So in the United States, we there isn't a law on environmental justice, but it is a policy of the federal government to promote and advance environmental justice, or at least it was, going back to the time when Bill Clinton was the president. So another thing that President Trump did when he became president was that he rescinded all federal programs advancing environmental justice. He also dissolved the White House Environmental Justice Council, the National Environmental Justice Association, and other various um, federal entities that are established to try to make environmental law better in the United States. So all of those laws have been rescinded. Other developments that are concerning is that just yesterday, the Trump administration opened up 60 million acres of federal land to timber development, uh, which, of course, is concerning on a whole variety of levels, but, not the least of which is climate change. I mean, it's not the same as development in Amazonia in the Amazon, for example. It's not the same as losing 60 million acres of the Amazon. That would be much more devastating, but it's where we have carbon sinks in the United States. It's in our national forests, and he's opened up those national forests uh, uh, to to uh, to timber cutting, to cutting those trees down. Um, he's also opened up federal lands to coal development and development of natural gas, uh, and done other things that advance or support and promote the fossil fuel industry. And not only that, the Trump administration has removed funding that had been set aside, more than $1 billion, that's with a B, $1 billion to promote renewable energy in the United States. So he's called on Congress to call that money back, to take that money back through what's called a reconciliation or a rescission process, revoking grants that had been given to venture capitalists and to companies that were promoting wind and solar energy. So that's, again, more of a reflection of sort of the antipathy that the Trump administration has uh, toward international environmental law than it is the antipathy that, an average American has. The average American supports renewable energy. Every poll shows up to 80% of Americans. Um, so, uh, but we see, concerns in other ways as well that we can talk about, and you're probably tired of hearing about all of them. But, like petitions to enforce the compliance mechanism in the Aarhus Convention, which was really, kind of an interesting aspect of international environmental law. It is an interesting aspect of international environmental law, but petitions are down, enforcement is down. So there are, the concerns aren't only in the United States about where environmental law is going, but there's hope in other ways of international environmental law emerging. Uh, I mentioned environmental human rights a little while ago. There is a push for a third covenant, a covenant in addition to the International Covenant on Civil and Political Rights and the International Covenant on Economic, Social, and Cultural Rights. There's a push to have another one about the environment. It's lost a little bit of steam, but it's out there. There's also a push to amend the European Convention on Human Rights to incorporate and recognize a right to a healthy environment, like all other regional conventions do. Uh, so the chances for that look, pretty good. So, there's reason for hope there. The next subject that I was asked to address is the impact of this litigation. What difference do these cases make in international law? And here the data is lacking. There's not much data, real data about, whether uh, recognition of a right to a healthy environment, for example, improves environmental outcomes. There are certainly success stories. The sort of the leading success story when it comes to the environment in international law is, probably the Montreal Protocol on substances that deplete the stratospheric ozone layer. So it's an international agreement about chlorofluorocarbons called CFCs. Um, and maybe if you're, for those of you who are, part of this conversation, CFCs aren't much involved in your life, but they were involved for most of mine until the last decade or so in all sorts of ways. CFCs are used as refrigerants, air conditioners use CFCs, and uh, aerosols, uh, uh, fire retardants, all sorts of things. But uh, they have an impact on the stratospheric ozone layer, and it's a good layer to have because it protects human beings from ultraviolet B radiation, and if you get too much, it's harmful. It can be harmful to crops and roads and bridges and all sorts of things. But countries around the world, they banded together to regulate the production and distribution of chlorofluorocarbons and created a compliance mechanism, a way to complain about, if a country wasn't complying and so on. So there are certainly success stories. Um, uh, and that remains to be seen as to whether that can serve as a model for addressing carbon pollution. But the impacts of rights-based litigation, I'll just focus on that, is, like I said, really mixed. Let me give you some examples. So uh, worldwide, there are about 300 cases that have been filed about climate change, ever, over my lifetime, about 3,000. And that's according to the Sabin Center at the University of Columbia Law School. So they counted up all the cases going back, in time. It's right around 3,000. About 2,000 of those cases are in the United States. About 400 are in South America. Um, so the next question is, well, what good are those cases doing? I'll just focus for the moment on the United States. Of those 2,000 cases, the takeaway number is one, just number one. So only one case in the United States history has ever reached the merits on climate change, has ever reached like a trial about whether climate change is happening and who's responsible and what to do about it. And that was just last year. That was about a year ago from this meeting. That was in Montana in a state case called Held versus Montana, where a state trial court found that the state of Montana was violating a right to a healthful environment recognized in the Montana Constitution. And the Supreme Court of Montana upheld that decision. So it's the only time in American history where there was a trial. There were opening statements and evidence and declarations and experts who gave testimony and cross-examination, and we're literally putting climate on trial. So 2,000 cases, only once has it ever reached the merits. So in no other case, even the celebrated cases like Juliana versus United States, has reached the merits. Cases have been filed in states all throughout the United States at the state level, like Montana and New Mexico and Florida and Alaska. None of them have reached the merits. There have been a series of cases filed at the federal level. Not as many, but some. None of them have reached the merits. Only, like I said, one ever at the state level. So it doesn't look as though rights-based approaches in states in particular on climate are making much of a difference so far. Well, what about elsewhere? Well, this is by my count. By looking at environmental human rights, there's been a huge push, as I mentioned, for international recognition of environmental human rights. 85 countries have done so, another 6 implicitly, and so on. So almost 100 countries have recognized a right to a healthy environment. So of those 100 countries, by my count, in 50 years, roughly, a little bit less than my lifetime, there have only been 100 cases that have reached an apex court. Apex, like the Supreme Court, the Constitutional Court, throughout the globe. That's an average of 2 every year. That's it, throughout the whole globe. And of those 100 cases, only 20 of them have ever reached the merits of anything, ever reached the question as to whether there's a right, what it means, and so on. That means in those other 80 cases, the courts dismissed those cases or they were resolved otherwise. They were dismissed for, lack of competency or admissibility or standing or something like that. Or they were lost for some other reason. So only 20 cases reached the merits. And of those 20 cases, only 6 reached outcomes that were beneficial to the environment. So in history of the almost 100 countries that recognize the right to a healthy environment and 100 cases that reached an apex court, a constitutional court, a Supreme Court, only 6 of them have been favorable toward the environment. And most of those are in South America. The majority of cases that have been even litigated or reached the merits are in Costa Rica. For example, 25 out of the 100 are in Costa Rica. And elsewhere, the cases that where the environment came out on top, like in Colombia with the Rio Atrado case, for example, and other cases that are in South America. Recent case that was, another example of how these cases can be really tough to win. It was a case brought by Peruvian farmers against an energy company in Germany that was just dismissed a few days ago. So it's another case that was dismissed that didn't reach the merits, that was rights-based, trying to do something about climate change in court. So those are just, some examples of what happens with these cases and whether they change outcomes. So there can be various ways, however, of trying to describe success at the international level. There certainly are grassroots success stories throughout the world to implement and advance, for example, everyone's right to a healthy environment. So, the marker of success isn't only court cases, it's all sorts of other things. It's legislation, it's regulation, and, it's cooperation in other ways, where there, at the grassroots level, there can be success. The last area to mention where it combines all of these things, international law and developments in court and developments um, uh, in recognizing rights and trying to just address problems, is rights of nature. So it's been another area that's grown substantially just in the last decade. The idea that, of course, that nature has rights, that idea isn't new. Nature has been recognized in all sorts of cultural traditions all throughout the globe for a very long time, but hasn't been law to support that in very many places. But just in the last 10 years or so, there have been these developments. Ecuador was the first country to recognize rights of nature constitutionally. It still pretty much remains alone in that regard of providing express rights to nature or of nature. There are statutory rights that have been recognized in New Zealand and in Bolivia and in other countries, and also domestically at the subnational level. For example, in the United States, where there have been cities and counties and states that where people have voted for laws that recognize nature. A famous one is out of the state of Ohio, where a city in Ohio recognized the rights of Lake Erie, which is a giant freshwater lake in North America. But for the most part, those two, sorry, not to be such a downer here, but for the most part, courts have thrown those laws out, finding that they're preempted by state law or they somehow violate the Constitution. So most legal efforts to recognize nature in the United States have failed. Um, the exception is tribal recognition, indigenous recognition of nature, because in the United States, Native Americans, indigenous populations, they're sovereign. They have their own, if you will, like their own states that they live in, and they have the capacity to do things that other states don't have. So there are in the U.S. developments at the tribal level to recognize nature. The Ojibwe tribe, for example, in the state of Minnesota, has recognized the rights of rice paddies to exist, given the cultural significance of rice for the Ojibwe tribe. And that's just one example, but there are developments there, and as well as in Canada, with recognizing the rights of nature by tribes. So I said I would go until 10 or 11:15, and I'm just about there. So there you have it, as a recap of where international environmental law comes from, what it looks like, how it's applied as a treaty or as rights, some judicial outcomes around the globe, and other developments. Uh, so, uh, so thanks for spending the last 35 minutes of your life listening to me, and I'd love to hear your thoughts, comments, and questions.
Well, thank you, James. I think it was amazing exposition about all the main of the features of international environment and how difficult it is to trying to apply international law in national both national and international tribunals. So we were discussing about that the previous hour with the students about sometimes rules, the international framework and reality not always goes in the same hand. So it's sometimes for a litigant as you, having this perspective is quite interesting. So I don't know if people have any question you want to ask to Jim. Take advantage. We have an expert here, so enjoy him, and we are going to take all the time just to make questions. So Eliana, go ahead.
Thank you. Thank you, James. And Dean, you mentioned like indigenous people and this like right to like nature and land. And I was thinking, have you seen a tendency in countries that have like strong indigenous communities to like to avoid the topic of like environment and climate change just because it will be a discussion that leads to these indigenous people and their right to land? Because I think as you were talking, I was thinking like this is a topic that is more talk in some like European countries where there's not this like um, this presence of certain groups and indigenous communities. I don't know what you think about this.
So is it Alana?
Eliana, yeah, Eli.
Eliana. So Ellie, I'm sorry. Forgive me. It's probably me. I don't understand the question. I'm sorry. Could we
No,
try?
don't. I can try to say it differently. Do you see an avoidance from countries that have strong indigenous communities to talk about the topic of environment, to avoid talking about the right to land and the right of these communities to live in certain places?
Okay, I think I understand better. And if I'm off the mark, just let me know. We'll get there. But I don't know. I haven't studied that question. So what I'm about to say is just off the top of my head. I don't know. But my impression, Liana, is that it has worked in many places in the other direction, meaning that countries with strong indigenous populations, um, uh, you know, Colombia, New Zealand, Canada, that there's been more progress in recognizing environmental human rights uh, than countries that don't have strong indigenous populations. And some of that, and again, I don't know, but my guess is some of that is simply cultural, that in some countries, uh, indigeneity uh, plays a stronger role culturally than in other countries. Um, in the United States, it's really a mixed bag. There's a, horrible colonial history associated with the United States, including in the United States, its treatment of, Native Americans. But as I mentioned earlier, there is a growing recognition of rights of nature and environmental rights in indigenous populations. And again, I don't know, but my guess is that over time that will help advance recognition overall as reflected in those cultural traditions. But let me ask you if that's okay. I know I'm turning the table here and maybe I shouldn't do that. But is this something you thought about or studied? And what are your thoughts?
That's a really good question. Oh, well, my thesis is about indigenous people in New Zealand and Australia. But it's not like focused on environmental problems and all. But as you were talking, I was thinking about it. And well, I did my international semester in Idaho, and I learned a little bit about like the treatment of like native people in the US and all. And I was thinking like as you were talking, um, maybe this is a topic some countries avoid just to not talk about like the right to these people of these people. But it's really interesting what you're saying about like the cultural aspect of it and the strength of the communities.
Yeah, right. I think it's interesting too, and I wish I knew more about it. So uh, if you ever get comfortable enough to, but I can't read Spanish, but if you write your thesis in English, I'd love to be able to learn more from it. But I think it's a really interesting thing. And like another example that comes to mind that I forgot to mention earlier of the nexus between cultural practices and environmental outcomes is Ubuntu. Um, in Kenya, like where I used to work at the United Nations Environment Program, where there's this idea of I am what we are. Does that translate? You know, I am what we
Mm-hmm.
are. It's a communitarian point of view, and just generally communitarian points of view tend to result in more favorable results for the environment. You know, it's very different than I'll pick on my own country. I'll keep picking on it. You know, the United States, where, you know, very individualistic and capitalistic. The environment just is no match for that. You know, that kind of individualism and selfishness. So,
Mm-hmm.
so with these, you know, cultural practices, oh, also, and, you know, again, Pakistan and Bangladesh and India and Nepal and Sri Lanka, and even in Japan and somewhat, you know, in China, you know, nothing's perfect, nothing's, you know, great, but the extent of environmental degradation tends to reflect those cultural practices along the way, and nature tends to do better when there's a deep cultural appreciation for nature, either religiously or culturally or otherwise. Does that
Yeah.
any
Thank you.
reflection on that? Does that make sense?
That was really interesting. Yeah, thank you.
Sure.
We have another question in the chat, but so this is from Deborah. How do you perceive, or what are your thoughts on the inclusion of environmental issues in free trade agreements such as the Mercosur and European Union agreement?
Okay, could you read it again, please?
Yes, how do you perceive, or what are your thoughts on the inclusion of environmental issues in free trade agreements such as the Mercosur European Union agreement? Maybe you don't know the Mercosur or European Union agreement, but you can talk about free trade agreements and the inclusion of environmental issues in that kind of treaties.
Yeah, well, yeah, so again, I'd have to think more about it. These are great questions. Okay. And
I
I'm
think it's
sorry that
a general question about what do you think about including environmental issues in free trade agreements, I think.
yeah, well, I think, I mean, I do have some thoughts about that. I have thought about that, but in sort of when I was younger, because I opposed the North American Free Trade Agreement because of concerns about environmental impacts. And so then this is NAFTA. The North American Free Trade Agreement is a free trade agreement with Canada and the United States and Mexico. And it does have a side agreement about the environment, but it's not enforceable. It wasn't out in the forefront of the agreement. And again, I think, you know, what is it now, 30 years on, we see the effect of that, where you know, it foregrounds and protects um, trade, which creates jobs, but it has resulted in a hastening, an acceleration of environmental degradation. So my my very limited point of view, but is very specific about that free trade agreement, is that it was no friend to the environment. Now there are other free trade agreements that you know, I'm familiar with other trade agreements, and I would also say in general they tend, at the extent that I've studied them, they tend to not do nearly enough to consider the environmental consequences of those trade agreement. And that's even putting aside all the human rights consequences of free trade agreements. I mean, can be good reasons for having open trade, freer trade, but you know, the victims, if you will, tend to be human rights and nature.
Okay, so I think if anyone else have any question, if not, I'm gonna ask you one question, Jim, and then I'll let you go. You talk about the lack of empathy of Trump administration on climate change, environment. So, what do you think are the real consequences for the United States and then for the rest of the world? Because the United States has certain influence. Do you think that this is going to be I don't know, ripple effect on other countries, or it's just United States and Trump's view about environment?
I think it's already having a ripple effect, and I think that's what we saw yesterday with what came out of NATO, to pay for defense at the expense of the environment. So I do think there are ripple effects, and it's so curious to me how things ended up this way. Um, I'm going to sound like an old fogey. Again, I don't know how that translates, uh, but look, even at the beginning of my career, it sounds almost absurd to say this, but the United States was a leader in environmental protection worldwide. Yes, the U.S. was the United States led negotiations of the Montreal Protocol on stratospheric ozone depletion. The United States was a huge supporter of the Rio Declaration. The United States was a supporter of forest principles that came out of the Rio Conference. The United States was a supporter of the Basel Convention on International Trade in Hazardous Wastes. The CITES Agreement, the International Convention on Trade in Threatened and Endangered Species, was negotiated in Washington, D.C., and the United States was a huge player in that. And that's what led to the adoption of uh, federal law in the U.S. called the Endangered Species Act. The United States was a huge supporter of the Ramsar Convention on wetlands. It was a huge supporter of international agreements to protect migratory birds. Um, so kind of all around the place, the U.S. was a leader in environmental protection. And when I started my career, I just thought that would continue, like that would get stronger. The U.S.'s positions and policies would improve over time, but it hasn't worked out that way. And that's for a whole variety of reasons. It could be about empathy, it could be about psychology, it could be about who knows what. But at this point in time, what it feels like is not so much antipathy toward the environment as antipathy toward the rule of law. So the United States has also been a beacon um, of supporting the rule of law. And look, I'm not, an apologist for the United States. I don't work for the government or anything like that. But we do have a tradition of respecting the rule of law in the United States. That means that presidents and congresspeople and governors and citizens respect, uh, for example, judicial outcomes. Like, if a court makes a ruling, even if you don't like it, you live with it. You don't try to assassinate the judge or harass the judge or anything like, or have the judge impeached or anything like that. But what's happened over just the last couple of months is an erosion of respect for the rule of law. So that means that traditionally especially federal courts, when they would step in to stop bad environmental laws or bad practices in environmental protection, uh, we don't have as many um, speed bumps as we used to because judges are being intimidated by the president. Yesterday, for example, the president of the United States did something no other president of the United States has ever done. And I don't know if any president has ever done, which is sue federal judges for opinions they issued with which he disagrees. So get me on that. I mean, it isn't just that the president publicly disagreed um, or called for impeachment, which he has, um, but he brought a lawsuit against federal judges simply for being federal judges because he just doesn't like their decisions. So the impact on environmental protection there is is going to be, I think, very concerning because the president has shown no interest in environmental protection at all. So it's likely that to the extent that judges are issuing opinions about the environment, that there will be opinions that he doesn't like. So that means that he'll be harassing those judges and suing them, and his supporters will be, camping out in front of their houses, and Congress will be trying to impeach them. It's just not headed in a very good direction at the moment. Now, I think that will pass. I think that the United States Constitution is resilient enough, and we still we still have terms for president, still 4 years, and presidents are still only allowed to serve twice, and that's still 3.5 years away. But between now and then, to get to the question, um, I think the United States is not setting an example for the rest of the world, and I think that other, especially autocratic leaders, will feel emboldened in doing similar things, like again, like we saw out of NATO yesterday, of switching funding from climate protection to national defense.
Okay, Jim, thank you for your opinion. I think it's quite interesting. So, Eliana, do you have any other comments? Yes.
No, just the last question. Jimmy said that the US is not setting the example. Do you feel there's a region or a country that is actually setting the example for the whole world, or at least regionally?
I have to think about it. I have to think more about it. I mean, I thought initially maybe, Australia, like you said, you part of your study is Australia, right? So Australia has some of the most progressive judicial opinions about environmental protection that have been issued around the globe over the last 10 years, mostly from one judge, or justice. I hope your work takes you to the opinions of Justice Brian Preston. Does it, by the way? Are you familiar with his decisions?
No, no. We haven't reached like that part yet. We're not studied that part yet, but I'm gonna take note.
Okay, yeah. So that's a place to look. But on the other hand, the national policies in Australia are very much like in the United States. It's energy development. It's coal, it's natural gas, it's drill, baby, drill. But there's a little more control over it, and it doesn't. Australia doesn't have all of the kind of political overtones that the United States has. And there's not a challenge to the rule of law in Australia, for example. In New Zealand, right, we still see, these really progressive agreements, like about the Waianae River, where there was an agreement between the Maori, um, and the government to recognize the rights of that river system. So that's really interesting. So that might be kind of setting the pace. But then again, I hear that there are problems with that too. So what to do about it? I I I think, if I could answer it this way, in the last 10 years, the cases that I thought were most surprising, it came from the most surprising place anyway. If I had to just say one place, okay, just one case, one place, is Pakistan. Pakistan, right? So Pakistan's constitution guarantees a right to human dignity. And there are a series of cases from judges of the High Court of Lahore, which is like it's the biggest city in Pakistan. I mean, Islamabad is the capital, but really the beating heart of lawyering is Lahore. And so there are judges in Lahore who have construed that right to dignity to require the government to develop climate policies, to require the government to protect elephants, recognizing the dignity of other beings besides human beings. And the Pakistani Supreme Court has issued similar rulings and has justices. Pakistan's a huge country, lots of, people who are affected by these opinions. The Pakistani Supreme Court has also issued opinions upholding the right to dignity in environmentally protective ways, in cases that involve, toxic pollution and a whole variety of things, finding that violates human dignity. So I just didn't see that coming. I was looking at environmental provisions and all that, and then these cases started being developed. And then we see similar outcomes, like a case about climate change coming out of Germany, a year ago, upholding the basic right to human dignity under the German constitutional system to reach climate change. So it's surprising to me that these other socioeconomic rights have been more successful in improving environmental outcomes so far than environmental rights in these constitutions. So, but let me again, let me turn it around on you. Have you found a country that you think is especially or gets it right?
No, I don't think so. Like, I don't think I haven't thought a lot about it, but I think, as you were saying, Latin America is putting its best effort just because we have a lot of like green space, like in the Amazon and all. But well, Uruguay in an ONU conference, they basically the speech of the president was, those who are like us, who are doing things right, we deserve like some recognition.
Yeah.
But I don't think there's like one region setting the example or one country setting the example.
But
But
there is
interesting.
power in these outcomes, and even the singular outcomes of decisions that have come out of courts in Uruguay and courts in Colombia and courts in even in Brazil, in South America. So-called Latin America is still producing better jurisprudence than any other continental region on the globe. The leading cases, the leading outcomes, come from South America. So when I'm looking for, when I teach classes in human rights, and I'm looking for cases that provide hope and ways to think about how to use the law in empathetic ways, in ways that uphold human dignity, in ways that seem fair, in ways that are uh, more reflective of the rights of women and children and the disenfranchised and the disabled. It's Latin America. So again, nothing's perfect, but when we look for where inspiration, just today, I'm at a conference earlier today at a conference with a member of the Supreme Court of Colombia, issuing opinions to uphold reproductive rights and women's rights and environmental rights through the Colombian Constitution in ways that are kind of unpopular with economic interests. It just it takes people to stand up, and more often than not, the other thing that I'm finding in developments is that just not every time, but more often than not, in the United States and in many decisions around the world, it's women sitting as jurists who are issuing these opinions.